Hi, everyone. Welcome to the GoldFish Report. I'm your host, Louisa. Today is Saturday, September 22nd, 2018, and this is our weekly Country Roads with Winston Shrout, our friend Winston, who is with us. How are you, Winston?
Well, doing pretty good.
And we have a special treat for everybody. We have our friend Steve joining us from Tokyo. How are you, Steve?
I'm from Tokyo. Looking forward to doing GoldFish Report soon.
Yeah, Steve is just going to hang with us for a few minutes, and we wanted to just make an announcement that we'll be doing a Goldfish Report. Since Steve is in Tokyo, we'll be doing that there, and possibly also meeting up with Benjamin Fulford very soon to do another interview with Benjamin. So, well, we're just going to look forward to it. We hope you're enjoying your time over in Tokyo, Steve.
Yep. No, I met with Benjamin already, and to look forward, we have lots to talk about.
Oh, that's wonderful. Our roaming correspondent.
Yeah.
So
Exactly.
today we're going to talk about third-party debt collectors, and this is an issue I think that has Winston has talked about previously, but not in great detail. So we're going to go into a little bit more detail about that. But first, we have some little light humor for everybody. Steve's going to stay with us and join us for this, and then he's going to have to sign off. But Winston, go ahead. What have you got for us? It's Saturday morning. We were supposed to do a report yesterday. We've had internet problems. We hope this isn't going to be interrupted today, although it might. But let's hope it works out for us so we get our report out today, and we could use some humor with what's all going on the political stage. It's just a disaster, and we can use some humor to lighten things up.
Yeah. You have to have a few laughs. Like I say, you had asked about this some of these stories about and then the fight started kind of thing. And so I want to first off, I want to show a little thing. You see that?
Yep.
Yep, we can see that.
Yeah, so the couple old timers sitting there, and one says, "You know why a woman's work is never done?" He says, "Because they don't get up early enough."
Oh,
I thought that was so cute. So I went and printed that out and put it on the refrigerator.
Well,
Thinking my wife would think that was pretty funny.
yeah.
And then the fight started.
Exactly.
that sounds like trouble to me, Winston.
Yep, that's right.
It was.
Trouble.
Like I say, it's just for fun. Some of these things, but I had, I'll report on a real life experience happened to me when I was, I don't know, maybe 15 or 16 years old or whatever. We were sitting at this. My mother put the supper on the table. We was all sitting there, and she'd gone in the bathroom and come back out, and she proudly announced. She said, "I have lost 5 pounds." And my father said, "Turn around, I think I just found you."
No, it's terrible. Terrible.
And then the fight started.
The fight started. You bet it did.
I mean, we was on bread and water there for about 2 or 3 weeks,
Oh, man. Funny.
He was on the hot seat for a long time, not only with her, but with us kids, because we suffered for it too, his smart remarks and stuff. But, well, maybe I'll just read some of these things. We've gone over these before. Actually, I got all this stuff from, believe it or not, Sean David Morton sent it to me.
Really?
Yeah, he's got a lot of jokes. He's a pretty humorous fella.
He's very witty, yes.
Yeah, I'll read through a few of them. We don't need to read them all, but here's Luis's favorite. He says, one year I decided to buy my mother-in-law a cemetery plot as a Christmas gift. So the next year I didn't buy her a gift. When she asked me why, I replied, "Well, you still haven't used the gift I bought you last year."
I love that. That is just my favorite.
That's how the fight started.
You didn't use the one I gave you last year. I just love it. I just love that. If you had an ex-mother-in-law like me, you'd love it too.
Yeah,
that is like humor.
Yeah, the one here says, I took my wife to a restaurant. The waiter, for some reason, took my order first. I said, I'll have the rump steak rare, please. And he said, aren't you worried about the mad cow disease? Aren't you worried about the mad cow? And I said, no, she can order for herself.
That's terrible.
That's when the
Then
fight
the fight started.
No.
Here's my favorite. It says my wife and I were sitting at a table at her high school reunion, and she kept staring at a drunken man swigging his drink as he sat alone at a nearby table. So I asked her, do you know him? Oh, yes, she sighed. He's my old boyfriend. I understand. He took to drinking right after we split up those many years ago, and I hear he hasn't been sober since. My God, I said, who would think a person could go on celebrating that long?
Yeah, I like that.
And then the fight started.
That's hysterical.
Yeah.
What's the other one? There was another one that you didn't mention last time.
Oh, I'll get to it.
Okay.
The next one says, my wife sat down next to me as I was flipping through the channels. She asked, what's on TV? I said, dust. And then the fight started. Now here's Louise's favorite. One of hers. It says, my wife was hinting about something that she wanted for our upcoming anniversary. She said, I want something shiny that goes 0 to 165 in about 2 seconds. I bought her a bathroom scale.
And then the fight started. Actually, the next one, the one in the mirror, I thought that was really
I'll get to that one. Yeah. But here's one that's pretty funny. Kind of a little bit of an adult thing. Anyway, it says, after retiring, I went to the Social Security office to apply for Social Security. The woman behind the counter asked me for my driver's license to verify my age. I looked in my pockets and realized I left my wallet at home. I told the woman I was very sorry, but I would have to go home and come back later. The woman said, unbutton your shirt. So I opened up my shirt, revealing my curly silver hair. She said, the silver hair on your chest is proof enough for me, and she processed my Social Security application. When I got home, I excitedly told my wife about my experience at the Social Security office. She said, you should have dropped your pants. You might have got disability too. And then the fight started.
That's evil.
That is funny. All fair is all fair, love and war.
Okay, here's the last one. Here's the one Louise is asking about. It said, my wife was standing nude looking in the bedroom mirror. She was not happy with what she saw and said to me, I feel horrible. I look old, fat, and ugly. I really need you to pay me a compliment. I replied, your eyesight's damn near perfect. And then the fight started.
These are hysterical, I'll tell you. I'm going to be thinking about this in 5 minutes. I'm going to start laughing and no one's going to know why, but you'll know why because it'll hit me again and then I'll start laughing.
Thanks for that, Winston. Thanks for that. Yeah.
Is that good, Steve?
Yeah, I'll leave you guys to it, okay? All right.
All right, thanks, Steve. Good to see you.
Take care.
We'll see you soon on a report and enjoy Tokyo.
I will. Ciao for now. Bye.
Okay.
Ciao.
Thanks.
Sayonara. That's quite funny.
Yeah. Good to see Steve again. Hadn't seen him for a little while.
Yeah.
Yeah, he's over there. What's he singing? Some opera productions?
He's working. Yeah, he's working hard over there. So, hold on a second. Yeah, so he's just busy working, and we're going to be doing some GoldFish reports, meeting up with Fulford, and we'll see what happens. We'll get some, news.
Yeah. Benjamin's always got some interesting things to report.
He does, and I find I quote him a lot, though. I mean, he's actually he's got a very good insight into many things. I'm not sure that it's always, I mean, he does rely on his sources. So if his sources,
Yeah, his information is
he's
only
very
as good
insightful.
as the people who are reporting those things.
Yeah.
And sometimes, this happens quite often. People that have an agenda will give information to support their particular agenda, which is no reflection on the reporter, uh,
Right.
because that he's just reporting what people are giving to him.
Right.
And if it's a little bit off here or there, that's okay. But like I say, I think that he's honest in his reporting. I mean, I don't think he's making stuff up, but he's simply giving what others have reported to him, and then we can do with it as we will.
Yeah, so I do appreciate his reporting as well, and like I said, I do quote him often, especially during POTUS reports. In fact, he's a source that I use
Yeah.
when we're talking about some of the world events that are going on, because of it does tie into some of the other reports that we talk about. So
Yeah. Well, today I thought we'd kind of step it down a little bit. We've been talking about some pretty deep things here for this last little while. I mean, this last thing we did on metaphysics and everything was, pretty pretty intense. And uh, sometimes we need to go a little bit deeper. Like I say, sometimes people need something that they can shoot for.
mhm.
And so, like I say, it might be a little bit difficult. And again, I'm just giving my understanding. And so other people might see it just a little bit differently and so forth. But I think by and large, it gives people pause to wonder, perhaps, have I become so restricted in my understanding that I'm not seeing some of the other things? And so when I come along, and say something about halfway weird or something like that, at least it gives people an opportunity to reevaluate, how they understand things. So that's good. But I thought because we had gotten, pretty intense here for the last little while that I'd kind of kick it down a notch or two and go into a little bit of technology. Uh, and so we've had a very difficult time this last little while, and I'm not going to report on any of that because for fear of another attack. But it's very difficult, folks, to get some of these reports out because this one is going. Louisa is going to put out another interview we had done with Scott Werner, and I'll tell you what, man, that was nip and tuck there for a long time to try to get that put together. So again, like I say, we're just doing the best we can to help people. Like I say, we get up early and do these reports and all that kind of thing, because I personally feel that like the scripture said, where much is given, much is required. And so if God was ever so kind to me to show me or give me certain insights, certain knowledge and all that kind of stuff, then I have a responsibility to act upon it, to share it. And so that's what we try to do. Like I say, it'd be a whole lot easier just to lay in bed and sleep for a little while longer and stuff. But we got, we have a responsibility. And so we try to make good on God's kindness to us. And so that's why we share. So anyway, today we want to get a little bit more into some of the concepts of what we call third-party debt collectors. I think a lot of people have been plagued with some of those problems, and so we'll talk about that a little bit. But I want to talk about it in the respect. Again, we've spent a great deal of time talking about the concept of prepay, not only from a spiritual point of view with the Jesus story, but also in our own commerce, with birth certificate concepts. And so we've talked a great deal about this, but in essence, anytime that you encounter some agency, some company, some government, or whatever that is trying to elicit money from you, that is a third party debt collector, a third party. In other words, they technically have no rights and defenses on the basis that everything in the public is prepaid. And so, you know, if you can kind of wrap your mind around the concept of the prepay and the implications of it, then when these things come along, then, you know, it would seem to be basically just trivial. Oh, really? This is what you want? Well, let me tell you. And so if you can ever get to the point that you have a good comprehension of these other things we've talked about in the past, about the birth certificate and creating the trust and all these kind of things, then when these other items come up, then you're certainly better able to handle them. And so what we'll talk about today is some of the little technologies and so forth. And you can have some pretty good fun with some of this stuff. I mean, if you like messing with the people and fooling with them. I was just talking to a guy yesterday, and he was dealing with some kind of insurance company. He had bought, you know, some kind of homeowner's policy about this or that, and his central, I mean, his I forgot what you call them. Anyway, it's the thing that creates the air conditioning and heating for his home. I guess the compressor or whatever had gone down, so he put it in the insurance claim. It was going to cost something like $3,000 to replace this unit so it would function properly. So he put in the insurance claim, and then he got into it with an insurance adjuster. It was just nip and tuck there for a long time. You know, going back and forth, you know, and I think this insurance adjuster wanted to pay him something like $700 on this $3,000 unit, and then they went back and forth, back and forth. And finally, he actually got to talking to the owner of the insurance company, and they got into just a bit of a discussion. And so anyway, a lot of times, you know, you can actually have some fun with some of this. I'll show you how we can have some fun. So anyway, let's. I wanted to first go into. Let's see here. I think a lot of people may be familiar with what's called the debt collection verification questionnaire letter type thing. And I'll just, you know, show it to you here. But anyway, in this particular case, and this is a real case, we had done this. I'd helped this fellow with this because he was being sued by a debt collector, and so this was actually incorporated into a case. Now, a lot of people like to use this debt collector's disclosure statement here. Let me just highlight this so people see it. This is what I'm talking about here. Yeah. So this is what we're talking about. And this is under this federal statute right here.
Okay.
All right. So this is what we're going to talk about a little bit. And I think a lot of people probably have seen this particular disclosure statement. And sometimes they just send it, you know, through the mail or whatever. But in this particular case right here, because we already had a court case going, we just went ahead and created a court pleading and put them under the gun. I mean, because, you know, when you just send a letter to them, a lot of times they just go away. Sometimes they do and sometimes they don't. But, you know, a letter just, you know, has one impact. But when you put it into a court pleading, now we're getting serious about this. So if you look at this pleading here, this plaintiff in this matter was this company here versus Paul. I've kind of sanitized this, not to give away people's names and stuff. But anyway, you'll notice that the suit was against the straw man, and then Paul himself came in this way right here, real party and interest. So when we do that, and we very often put pleadings in as real party and interest, and and the key word there is real, and that is Paul is not coming in as a fiction. Paul's coming in as a real man. Now, technically, when you do that, you're pushing this, off into what we would call the law side. And because if you'll notice this whole case right here, I mean, this is all fiction until you get down to Paul as the real party in interest. See, I think a term that people might be familiar with is what's called at law. For instance, an attorney at law.
Right.
Yeah. And so when you use the term in law, it takes it out of the fiction and takes it into real world, real. And so it's we've used the illustration, for instance, of talking about being at the lake versus being in the lake. There's a world of difference. World of difference. And so when we start to talk about at law versus in law, there's a world of difference, and the consequences are different also. So that's what this Paul is doing here. He's coming in as real party in interest. And so he's taking it out of fiction, he's taking it into reality. All right, so what's wanted here is as the title says, demand. A demand for debt collectors verification, for this United States Code. Now, the fictions are regulated by the statutes and codes. If people don't know all your statutes and codes, they're all in the fiction. And so the only joinder, if I can use that word, and that's not really the right word, but the only real liability of statutes and codes has to do with fiction. And you'll notice all the court cases that go in, except the ones I put in, come in the fiction. And so this fictional plaintiff and this fictional defendant are bound by the statutes and codes. So we're using this particular code, this particular statute right here, to bind them. This is what you have to do according to your responsibilities. So anyway, this is a lot of people have seen this, called Debt Collectors Disclosure Statement. I don't know who put this together. It's been around for as long as I can remember. Anyway, so it starts out, in the nature of. Now this is interesting because, again, when Paul, the real man, the real party in interest, comes in, he does not want to pollute what he's doing with any fictions. So this debt collector's disclosure statement is in the nature of Fair Debt Collection Practices Act at 15 U.S.C. 1692G. So he says the debt collector shall attach to this completed disclosure statement a verification, which means confirmation of authenticity by affidavit or oath of the record relating to each of the following. So he's going to pin them down. He's going to pin them down now. We're going to find out just who we're dealing with here.
Hmm.
That's what it amounts to. So some of the items, that would be required in this disclosure statement would be the name of the debt collector. And like I said, because once you understand the prepay, everything in the public is a third party, and they're technically attacking the trust. Because I was just talking to a lady the other day, and we were talking about some of the situations that she was dealing with. And I said, you're kind of struggling around over here in this court, over here on this other side. I said, why don't you just take this whole thing into probate court? She said, probate court. I said, well, yeah. I said, this entity over here is stealing money
Mm-hmm.
from your assets, the Straw Woman Trust, which is a dead party, because it's in all capital letters. Remember, we talked about anything written in all capital letters is either a U.S. vessel, a corporation, or a dead person.
Right.
And so all the vouchers or whatever they were doing in this court case were an attack upon the trust. And I said, well, if they're stealing from the estate, I said, you could very well take your pleadings and so forth and either start a new case or move this case over into probate.
Hmm.
Because the duty of the probate judge would be what? To guard the assets of the estate. And if you go make a complaint to a probate judge that somebody is stealing unlawfully from my estate, then what would be the duty of that probate judge? Protect the estate. And so anyway, I don't want to get into probate right now, but in any event, I think maybe you can see what I'm implying here.
Mm-hmm.
The implications are right there. So there have been some who have taken some of these things right straight over to probate. And really, well, I'm not going to get into probate now. But anyway.
But hold on, well, can't they bring this up into probate then? Can't they refile this in your probate court?
Yeah.
And so how would the judge look? I mean, if they're honest, the problem is we have too many judges that are sadly dishonest. So,
okay, a probate court would approximate,
mm-hmm.
and put it that way,
Mm-hmm.
a probate court would approximate an Article III court where you're dealing with real things, real property, money, houses, cars, whatever, not the title to them. And so, when you get involved in the probate concept, you're approximating. I say approximate now. You're approximating an Article III situation because you're dealing with real things, real money,
mm-hmm. Real assets. Yeah.
Yeah, and so if someone is stealing from your estate, mm-hmm. then you might want to take it up with a probate judge. I think you can get a lot better leverage talking to it, in that vein. Mm. And so anyway, people generally think, well, probate court's for dead people. Well, it is for dead people. But again, you got a dead entity out here that's the title to the trust that has the assets that belong to the estate, and somebody's stealing them. So, you can hit a pretty good lick over there in probate court if you want to pursue it that way. But we're not going to talk too much mm-hmm. about that right now.
Right. Because if we're dead and they're using our capital letters in the other court, then that represents a dead person. So why wouldn't they preside over that dead fictional entity?
Yeah. Uh-huh. Yeah.
The dead.
Yeah.
Uh-huh. Interesting, Winston.
Huh?
Interesting.
Well, yeah, just what to think about the concepts of it.
Mm-hmm.
All right. Well, let's get more into this disclosure statement. What's being tried to be done here. So they want to know the name of the debt collector. Now, generally speaking, a third-party debt collector is easily identifiable. Somewhere on their correspondence to you is going to be in bold print, because this is required by law. In bold print somewhere on whatever correspondence they send you, they're going to say, this is an attempt to collect a debt. It's going to be in bold print. So people call me up a lot of times and say, well, I got this letter here, somebody trying to do this, that, and the other, on this debt, and I say, well, okay, look on their correspondence. Does it say this is an attempt to collect a debt? And that's a third party, which means they have purchased for pennies on the dollar some alleged debt from some original debt holder. And some of them try to fool around with some of that. If you
Yeah,
catch them out, they're in trouble. Huh?
there's some law that pertains to transferring this that allows them to do that.
Well, they can sell the debt. They can sell the paper anytime they want.
Okay, but
But the question is,
yeah,
when someone approaches you,
yeah,
what is their position they're coming from? And if they are a third party debt collector, they got to tell you. And they do.
yeah.
Anyway, so again, you want to know who the name of the debt collector, address, and all that kind of stuff. You want to know what kind of account numbers that they're actually trying to deal with, and the amount of debt owed. You want to know the date this debt become payable. Did debt collector purchase this account from the original creditor? Yes or no? See, because we so many times we see it. I mean, let's say for instance on credit cards. When we've done acceptance for value on credit cards, and then the acceptance zeroes out the account, and then the bank will sell the paper to a third party. And then you'll get a letter from the third party debt collector, blah, blah, this and blah, blah, that. You might come back with this document here or other kind of things that I'll show you in a minute. And they say, oops, and they'll resell it to another fool. So you want to know, from this party, did you purchase this account from the original creditor? Because, sometimes, things just keep getting passed around. I mean, I've had people call me or correspond with me and saying, hey, some third party debt collector, popped up on an account that's like, 6 or 7 or 8 years old. And they do. It's just, it's a gamble. It's a risk on their part. And if they can't easily collect, they'll sell it to somebody else. So like I say, it might, whoever shows up with these claims and everything, you want to know, did you get this from the original creditor, or have you bought it third or fourth hand from some other collector? You'd want to know that. Okay, so here number 10 is here, same thing. Did debt collector purchase this account from a previous debt collector, yes or no? See, we're going to talk about it in a minute. Who has rights and defenses on an instrument? We'll get into that in a minute. But only holder in due course has rights and defenses on an instrument. Well, let me just get into it right now so people understand what we're referring to here. And that is, let's just say you go and take out a loan, I don't know, to buy a refrigerator or whatever. And so you go to the appliance store, you say, well, I want to buy this refrigerator over here. I don't have the money to pay for it. And so the appliance company said, well, we'll carry the paper on this. In other words, you can put down a down payment and make payments to us until it's all paid off. And so you fill out an application. An application is always a promise to pay, isn't it?
Yeah.
And what is a promise to pay? It's a promissory note. Now, in the case of an application, it's what we would call in negotiable instruments, it would be called a promissory note with baggage on it. So there might be terms and conditions and all kinds of things, interest and blah, 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 whatever. But an application is a promissory note. It is a negotiable instrument. Now that appliance dealer, if they, for whatever their reasons, maybe if you got behind on your payments, they didn't look like they were going to be able to recoup, and it was just a pain in the neck for them to try to, to carry through with it, they might just sell it. And there's plenty of companies, attorney firms, and all kinds of things that buy debt paper. They do. So let's say the original amount on that promissory note, let's say was I don't know, let's say $5,000 for this refrigerator. And so it got paid down a little bit, and then something happened, and it wasn't being paid off anymore. And so they would sell at a discount that paper to a third party. And they might sell it, for 10 cents on the dollar or whatever. So some third party debt collector might buy a $5,000 note contract for, let's say, $500.
Mm-hmm.
And so they come to you in the hopes that they can recoup their $500 plus a little bit of a profit. Now, that's just what they do. But the question is, under the Uniform Commercial Code in Article 3, who can exercise or execute? In other words, who has rights and defenses on that note? See, and so the rights of execution are with the holder in due course, which should have been the original creditor, should have been. But if the original creditor sells the note for however much, if they sell it for $500, if they sold it for 10 cents. They have lost their rights and defenses on that instrument. But the guy who buys it for the $500, can he be holder in due course on that note? Well, he would. It'd take a little bit of work on their part to do that. But technically, a third party debt collector has no rights and defenses on whatever debt paper they buy. They have no rights. They can't execute it, because they have to get into the position of holder in due course in order to do that. It's right there in the Uniform Commercial Code, Article 3. And so, they're taking a risk, they're taking a gamble that whoever it is that they're dealing with doesn't know that. And so it's a little bit of I don't know what you would call it, tomfoolery. That's what it is. Tomfoolery. That's what it is.
Well, can't they just claim because they purchased the debt that they're now the new holder in due course?
Nope. If you
Why
look
can't?
in Article 3, what it takes to become holder in due course.
You have to have an original signature.
Well, aside from that, you have to have the original signature instrument. We'll talk about that in a moment. Mm-hmm. But aside from that, is the original creditor, do they rise to the status of holder in due course? Usually not. See, there's a difference between a holder and holder in due course. Mm-hmm. What would that appliance store manager have to do in order to rise to the status of holder in due course? He'd have to accept it.
Has to accept what?
The contract, the application. He would have to actually accept it. Now, if he wanted to, if he's big enough, he could take it to the federal window for collection. That's holder in due course. But in order to do that, he would have to accept it or endorse it. Now, again, when we start talking about endorsement of instruments, the rule is last endorser has the liability.
But aren't they doing that anyway, though? When they purchase the debt, aren't they going to the federal window anyway
if
to
they're big
collect on
enough,
it?
they would, but not just a appliance dealer wouldn't know to do that. But if they did endorse it, putting them into holder in due course status, they could legally take it to their bank and make a special deposit of that instrument. But they don't know to do that. I mean, well, who knows to do it? Not very many people.
Well, that's private side, though, isn't it?
Not actually. Not actually. But that dealership could, in fact, take the application, do the proper endorsements on it, take it to their bank, and make a special deposit of it, and then the bank would be liable to make the presentation at the federal window or handle it in a different way. And usually they do handle it in a different way. For instance, I mean, we had done some years and years and years ago. We were doing some things, and this party I was dealing with had created a bill of exchange on this particular transaction that was going on, and he took that to his bank, to the banker, to the manager, and said, "I don't want you to collect this." He said, "I want you to make presentation for honor or dishonor." So the banker said he could do that. He said he would do it. And so the banks have the responsibility. They're under charter to do this. But the banks, of course, are in the business of stealing. And so this manager, he stole it. He stole it rather than taking it to the federal window as he should have. He stole it. And we had a dickens of a time getting that back. And finally, we had to get to the corporate offices. And anyway, that's really complicated. But what I'm saying is that if the owner, whoever of that appliance store wanted to, he doesn't need to take it to the federal window, but he would have to endorse it, which means that now he's liable on that instrument, on that note, and he could in fact take it to his bank and make a special deposit, and then the bank would monetize it for him. Like I say, this sounds a little bit complicated, but really it's not. If you just know a couple or two or three, principal things. And, one of the things you have to understand is that last endorser has liability. They have the liability. It's theirs at that point. But until endorsement or acceptance is done on an instrument, there is not any holder in due course on that instrument, and therefore it can't be executed except by extortion. And so these third-party debt collectors, in their wildest imagination,
so they're the extortionists,
can't be holder in due course because, number one, they're never going to get the original signature contract. And when we get into a little bit more down the road here, we'll show you how to use that very concept to overcome a third-party debt collector. So, like I say, this might sound just a little bit complicated because you're not conversant with some of these concepts, but these are the concepts that actually apply. Anyway, getting back, so this number 10 here, it says, did the debt collector purchase this account from a previous debt collector? Yes or no, blah, blah, blah. So the transfer of rights to this account was done by which the following method, either by assignment, negotiation, novation, or other. Explain how the rights to this account were transferred. And the rights to the rights on the account can only be transferred if the next party along, either by assignment, negotiation, or whatever, got the original signature document. If you don't get the original, you're wasting your money. If you're a third-party debt collector, you're wasting your money because you can't execute on a copy. You can't do that. I mean, we've had people going to court, and some, third-party debt collectors trying to take this position, the other position, and so whoever it was would just ask the judge, Well, they brought a copy in here, but you know there might be 100 copies of this, Judge. Am I liable on all 100 copies? See, a copy don't fly.
Yeah.
And so if these debt collectors and so forth are giving somebody $500 for a copy of an application, they're crazy. You can't collect on a copy. Anyway, then you got some more questions. What are the terms of the transfer of rights? Blah, blah, blah. So 14 here says, in regard to this account, is the debt collector currently the owner, assignee, holder in due course, or other? Well, that's a trick question. They're not any of those. It's a trick question. But if they answer it, you know, they say, well, okay, I'm the owner of it, or I'm the holder in due course, or whatever. That's a lie. And go ahead and tell a lie in court and see what happens. See what I mean?
Mm-hmm.
So this is real good, you know, in a particular court situation if somebody wanted to use it this way. Mm-hmm. So then, 15, it's a transfer, you know, if the transfer of rights to this account was by assignment, was there consideration? In other words, did you pay for it? Did you give money for it? You know, what's the nature? Then it goes through a lot of this stuff. Number 21 says, does debt collector have knowledge of any claim or defenses to this account? They don't. It's impossible. See, this is a catch-22 type request here.
Okay, can you explain?
Yeah, there's no answer to these questions.
Mm.
They can't answer these. It's impossible. It's like asking, you know, can I get lemon? You know, can you get lemon juice for squeezing a turnip? No, you can squeeze that turnip all you want to, but ain't gonna be no lemon juice coming out of it now, is it?
Right, but we need to understand like what you're talking about here. So no matter what they put down for a third-party debt collector, they may fill these in anyway. They may fill these blanks in
They
anyway.
might, and they might perjure themselves too by doing so.
Well, the burden of proof is on us.
Well, not if you catch them in a lie.
Well, that's what I'm saying. The burden of proof of the lie is upon us.
Well, again, what people need to do is understand UCC 3. If you go, I think it's in the 300 section, go and study holder in due course status, because only holder in due course has rights and defenses on an instrument. And if a holder in due course came into court, that'd be one thing. But, you know, if somebody's smart enough to know how to become holder in due course on an instrument, then, you know, why go to court? Take it to your bank. Make a special deposit, because it's money. See, when you say, if you go talk to a banker and you say instrument to a banker, what does the banker hear? They hear money.
Yeah, sure.
To them, an instrument is money.
Right.
Sure. And so if you bring in a promissory note that you've endorsed, it's just like if somebody gives you a bank check. A bank check is actually a promissory note. Could you make a deposit of that bank check into your account if you don't endorse it? No. And so when you endorse an instrument and get to the status where the liability on the instrument now belongs to you, then you can do with it what you will. But in regards to an application for a loan, which is a promissory note, if the holder of that does not endorse or accept it, and you can do an acceptance on it just like you would do an endorsement. If they don't do that, they cannot execute because they have no rights and defenses as a holder. And I know this might sound a little bit complicated, but this is standard negotiable instrument law. It's just standard. And so these all these questions right here, that's why I say many of these are catch-22 questions because they cannot be answered truthfully. You can't squeeze a turnip and get lemon juice out of it.
Okay.
And so when you squeeze them with a turnip question and they come back with lemonade, they just lied.
Right, but people should really study this 300, this USCC
Yeah, well, this
300
study the concept of
reform.
hold in due course,
Right.
because that's where the real power is. See, this is exactly what we do when we do acceptance for
Right.
value.
Right.
We take a presentment and we do our acceptance on it. What does that make us of that instrument?
The holder in due course.
Exactly. Now, as holder in due course, what do I want to do with it? It's now mine. See, I
Right.
have the liability on that. It's mine.
Right.
It's not theirs anymore. And so they foolishly send you what's known as an incomplete. Why is it incomplete? I think you can read about incomplete instruments there in UCC 3 I think it's 115, as I recall. So when they send you an incomplete instrument, why is it incomplete?
Because you didn't
Because
sign it.
they didn't send their check with it.
Right.
Remember, it goes right back to the basic maxim. Whoever creates a liability must provide the remedy.
Mm.
And so when someone sends you, whether it's a bank on a mortgage or the IRS or whoever, when they send you a request for money, because everything is prepaid, they're trying to create new money. In essence, that's what they're doing.
Mm-hmm.
And so when you do the acceptance on it, you become holder in due course. And just because we're nice people, we go ahead and supply private credit to settle a public debt. That's what acceptance is all about. Now, a lot of people like to do conditional acceptances. I don't personally. But again, when someone sends you an incomplete instrument, which means they didn't send you the check for your endorsement, then you can take control. You know,
Winston,
I
do you
know
think?
it's a little bit hard if you're not
Yeah.
in the mindset.
Right. But do you think that there, for countries that provide, I guess you would say, the advanced education, secondary, or I would say, postgraduate or graduate school, level higher education for their citizens, as you know, the United States doesn't. But do you think that the people who take out school loans should be charged interest on them if they're to be working to benefit the economy of the country? Do you think they
No,
should be?
again,
Right.
when you take out a student loan or anything like that, it's already prepaid. So why are they asking you for money? Because they're crooks, inadvertent crooks, perhaps. But that's crooked to do that, because your signature on the promissory note, called the application for the student loan, your signature on that just created that money.
Well, they actually do it electronically too.
It's an electronic or whatever, but
Yeah.
it's an instrument.
Yeah. Mm-hmm.
And when you say instrument to a banker, what does the banker hear?
Money.
Money.
Mm-hmm.
All right. So they take the application and however they handle it, if they want to endorse, put it into a special deposit in a bank or take it to the federal window for collection and so forth.
Mm-hmm.
They got the money that you just created with your signature.
Well, how do you know that?
If your signature hadn't been on that instrument,
Mm-hmm.
would that instrument have been any good at all? No.
How can you follow that paper trail, that money trail? How can you know if they've already cashed in on that
Sue them in
money?
court and subpoena
Mm-hmm.
that instrument, the original
Okay.
See, we're going to get into some technology where we go and do subpoena deuces take them for original signature documents. See, like I said, this one time, some people reported to me that they had been fighting a foreclosure case, uh, on which they had done an acceptance on the mortgage and all those kind of things, and so they were in court, fighting with this, and
Mhm.
so finally, these people told the attorney for the bank, "We're going to do a subpoena for the original signature acceptance that we gave you, and we're going to subpoena Treasury to see where the money went."
Uh-huh.
And you know what? That attorney had their reconveyance back in their hand in 2 hours.
So,
Because again, that attorney knew this as sure as day that if they went and subpoenaed Treasury and seen where that money went on
right,
that acceptance, that somebody going to prison. Somebody at the bank is going to prison over that because they stole the money. You remember we talked about this in the past, about
yes.
how the bank send the money on your acceptances. They might send them to the Central Bank of India or any place.
Mm-hmm.
But when you do an acceptance, especially to bankers know exactly what to do with an acceptance. They take it to the federal when they get paid on it.
Okay, so why did this change for student loans? Why can't people do this for student loans
You
now?
can. You can accept a student loan for value, and then you'll have to go and sue them in court, and then start the subpoena process to see where did the money go.
So the universities likely already took the money from the government.
Absolutely.
So the university went to the federal window and took that money.
Absolutely.
But the
And you might
government,
want you
but the
might want to sue
government,
them in probate court, huh?
right? But the government is the one who's claiming trying to recover the debt. So,
Okay.
since
Let
there
me
was a
say,
middle person who actually received the money, since you don't receive the money, the university does.
yeah, yeah. When you took out a student loan, they didn't give you any money, did they?
Well, I mean, if there's any residual, if there's anything left over, you receive the difference of whatever your actual costs are with whatever the
Well,
loan
that
is
could
that's
be.
given you. So you could receive some. Yeah, there is some that you could receive.
I personally wouldn't touch that myself, but
Mm, mm.
because we have to keep everything at arm's length. Anytime money comes from Treasury, man, always keep it at arm's length.
No, it would be from the university because the university would receive the full amount, but whether you use the full amount or not is up to you, is what I'm saying. It's discretionary. And so then that money gets refunded to you from the university.
Okay, well, let's not get into that now.
Yeah.
Let's stick with this because we're going to get off course.
Yeah, no problem. It's just that
That's a
I'm trying to understand who actually owns the debt, who's been paid, and who is claiming that they own the debt, because that's how it works in universities and student loans. You may not use all of it, in which case you would receive a refund from the university. So that means the university went to that Treasury Department then, or at least the university was paid by some Department of Education, I guess, and so they receive that money. So then it's some of that money can be refunded to you from the university itself, not from the government.
if that were to happen, my personal recommendation to anybody that would happen to would
Yeah.
be to endorse the check they send to you and endorse it and give it back to the university.
Mm.
The only way you could handle that otherwise is to set up a trust account in your straw person name,
Mhm.
deposit that check into that trust account, and so where you would be the beneficiary. But if you go and cash that check into
Yeah.
your personal account, man,
Mm.
technically the Treasury could prosecute you for theft. It's not your money.
I don't know. All right, it's a little
Okay,
complicated. Yeah, it
it
is
is
complicated.
complicated.
But this student loans are a big issue people have. It's not like I'm asking, because it will only benefit one person. This is millions of people have student loans and are in this situation. And
Okay, here's how you handle student loan problems: is you sue in court. So you have subpoena power.
Okay.
And when we get into, running the court process on this, when you get into court, then you would subpoena any and all original signature documents that create a liability for you to the whoever gave the student loan, and they can't produce it. They can't produce it
Well,
because
the
it's long
federal.
gone. Huh?
So what do they do with those original signatures then?
They send it to Treasury. That's how they get paid.
Oh, I see. Because that original signature actually is what allows them to get
Well, do
paid
you
from
think Treasury
Treasury.
is going to take a copy?
No. I'm just, hey, you know what?
Yeah.
It's just good to make sure. That's why I see what you're saying. No, that was the missing link. I know it was obvious to
Oh,
you.
okay.
No, it was obvious to you, Winston. Come on, you're not from here. But it's not obvious to a lot of us, okay?
Uh,
This really no. I mean, obviously that's how it would have to happen. Because if you did sue them, you're really presuming that they've already gone to the Treasury Department and
yeah.
have gotten paid. So based on that presumption, they will not be able to produce an original signature, and then they cannot be the holder in due course.
Okay. What might happen? What might happen? Whoever extended that loan to you, they may have taken it into their bank, and not Treasury.
Mhm.
They could take the original to Treasury and get paid on it, or they might take it, endorse it, and make it into a special deposit in their bank, and the bank would create the money for them. But somebody has to create the money.
So whether they do it or whether the bank does it, they're still
Yeah,
going to Treasury. There still needs to
yeah.
be a way to.
Well, yeah. But somebody has to actually put up the money into your account so you can buy books, so you can pay for your
Classes.
dormitory and all that kind of stuff.
Mhm.
Somebody actually has to create the money to do that. And so it's either the Treasury or it'll be a bank. I'm just telling you, anytime you say to a banker, application, instrument, they hear money.
Right.
To them, that's money. Now we use the words, notes and all that kind of stuff.
Hmm.
But as an example, I mean, just think about this a minute. Okay, so somebody sends you a check for something, that,
Hmm.
say they send you a check for $100. Okay, just go ahead and make a copy of it, take it down and see if you can deposit it in your bank account. Will the bank take it? Oh, hell no. They have to have original signature now, don't they? So copies don't
According
work.
according to their own rules.
Well, common sense.
No, I'm just saying that according to
Okay, yeah,
their.
there are rules, whatever.
Yeah, no, what I'm saying is that what you're doing, just to be clear for people, what you're doing is you're using their own code and statutes to reclaim this. I feel like I'm doing I feel like I'm doing a commercial for your reclaiming your status and assets video
Yeah.
because I just heard myself saying the whole thing. That's exactly what you're doing. Yes.
Uh-huh.
You're reclaiming your status and asset. So it's not, this video is really helpful. I think this particular show, this or report, I should say, because it is now kind of making to, like a 360. It's putting the whole thing into context so that you understand then what it really means to reclaim your status and assets. That's not such an abstract term now. In a very real life situation here, we're talking about third party debt collectors. There, it doesn't get more obvious that this is
Yeah.
a status issue. This really is
Well,
a
yeah,
status.
yeah. A holder in due course status is ever so important when dealing with instruments.
Yeah. But it's
Eh,
status in terms of your status as well, because if you're dealing with a fiction, uh, then then so you're saying here that people are using private uh, assets to settle public debts, and that you don't like to intermingle. You don't normally like to intermix that, but because they're already right. So you've just highlighted that. Why would you want to highlight the real person though? Why wouldn't you want to continue to deal with the fiction and say this is You want to take control of that status that you have and the status that they created. And so you want to keep it in the public, though. You don't want to bring in the private side. You don't want to intermix that and commingle. Sorry, it's called commingle.
It is called commingling to a certain extent,
Mm-hmm.
but when the public, which operates in fictional commerce,
Mm-hmm.
injures
Mm-hmm.
a real man,
Mm-hmm.
then you have to stop, correct the injury before you can go on. So when you come in as the real man
Mm-hmm.
in a court case,
Okay.
and you allege that this case right here or whatever's going on has injured the real man, then they have to stop and redress the injury. And so that's what this disclosure statement here is all about. We're trying to get down to, was the real man injured or not? And
And
so by answering these questions, we're going to find out.
so this is something that would be submitted in probate court or just civil court?
No, yeah, civil
Any
court's
civil?
fine. I'm sorry. I'm kind of sorry I got off on all that probate stuff, but I'm just trying to,
No,
give another alternative.
no, it has everything to do with status because,
Well,
quite
sure it does.
honestly, well, that's why it's important to mention that was
Absolutely.
very important to mention. I'm glad you did go down that path because it puts things into perspective, because we are dealing with the fiction, and we have to remember that we're not really fiction, that we're humans, and that this fiction, in other words, it's, I think, really helping to distinguish the fiction from the real, the real person. It just reinforces this, because it's always been, I think, a very difficult concept for people to really understand what constitutes their action in fiction versus what constitutes actions that are private. It's not something we were raised with, so it's not like necessarily second nature to really
Yeah,
understand the difference. But this is explaining this. This keeps referring to once they go to that federal window, that Treasury window, that changes everything, because they're already paid, and then they come after you to pay a second
exactly.
time because of
They're
the
thieves. But to prove the thievery, you're going to have to take them into public court and start subpoena.
yes, very clear. How do we prove to what if the court, well, the court is going to question and test people who come in with this kind of technology, and we need to prove that there is prepay. We need to
No, you don't
show,
need. You don't.
show
Okay,
that
you don't
we're
need to
going to need
prove the prepay. All you have to
judges do.
do again is bring in about with subpoena deuces take them. You're going to subpoena any and all original signature document
Mhm,
that proves the liability. And when they can't do that,
mhm,
what does the court say? There's no liability here.
mhm.
See? And so if there's no liability, then whatever relief and so forth you're asking for, comes about. And so again, you have to understand prepay. You have to understand that, but don't try to plead it in court, because they will not allow you to put that on public display. They will not do that. They don't want the other people in the public to see that.
Right, but you still have to make the case. They will test you very thoroughly when you walk into a courtroom to
If
make
you let
sure.
them,
Well, they will do it. Whether they will continue questioning you. So you
if
have
you
to
let
know.
them,
Well, if you're in that courtroom, you're in their jurisdiction.
no, they're in my jurisdiction.
Well, it's the admiralty system. If you accept, don't isn't that accepting?
Watch my fingers.
Okay, just try to explain this for people, so in case it's confusing, because these can be confusing concepts.
When a real man
Hmm.
walks into a fiction court, whose jurisdiction is it?
I
The
think
real man.
it's God's actually, which would
Well,
be the
God,
real
what are you
man.
going to say?
Exactly.
Jesus Christ himself walked into court. Whose jurisdiction would it be? It'd be his. If you allow them
Right.
to take jurisdiction over the real man and go into fiction, they will.
Okay, excellent point. See, this is why we have to, this is important. This really explains the concept of the fiction versus the real person. The capital and lowercase letter, which is what you're highlighting there, versus the all caps. That courtroom is in all caps. I guess will
Gonna make it any plainer?
yeah, no, it will presume. Well, it will presume it's not the same, Winston. Just seeing it on paper, I'm telling you, this is not, some people need to have a little bit different kind of, examples and explanations to really understand. And that, because they know they're a human being, they don't understand how this is, how this can be, fiction versus real. But this is because the jurisdiction is naturally, I would say, default. It's going, when you walk in that courtroom, like you said, if you don't put it in your jurisdiction as a real person, they will proceed as fiction.
Yeah.
That's what you're saying.
Like I said, there's one real example of, a friend of mine. He got involved in a civil case, and he was being sued. Let's see, I think, was he being sued, or was he? Anyway, there's a civil case going on. He hired an attorney. The attorney had done a terrible job, so he fired the attorney, and he attempted to go back into the fiction court and talk. And the judge just treated him real bad. He called me up and said, "Hey, how come that judge was talking like that to me?" I said, the next time you go in, just tell the judge that you're, a third party intervener, a real party in interest, and see what happens. He did. Judge talked to him totally differently. Just tell him.
So a third party intervener is the real person.
Well, okay, what I'm saying is your status, the first time he tried to talk to the judge, he didn't have any status. He was a nobody off the street. He could have been a bum for all the judge cared.
Well, they call that, well, didn't he try to represent himself as pro se as opposed to pro per?
Okay, stop using those words.
Like, come
What I'm
on.
saying is his status changed when he told the judge.
Told the judge what?
His status.
What did he say his status was again?
He said he's a third party intervener, real party in interest.
Right, he said the judge, exactly, but before that, he had
He
no
didn't tell
status.
the judge. He didn't tell the judge anything. He just started talking.
Okay.
The judge didn't know him from Adam. Like I say, until he told the judge who and what he was, the judge, for all the judge knew, he's just some bum
Okay.
walking off the street.
Okay. So he told the judge that he was third party intervener, which is really pro per, isn't that right?
Stop using pro per.
Okay. Tell people why.
Those are tricks.
Okay. Will you
Those,
explain?
those are legal. Oh, we're getting off into a lot of stuff. We're not talking about the subject matter
Well,
we're going to go into.
no, but if people don't understand, I'm sorry. If I'm asking the
Okay,
question, it's because I'm sure
when you
others are
say
asking
pro
it too.
per, the full word is pro persona.
Yes.
But you're still coming in as a fiction. And the term pro se basically means, it's a Latin term, which basically means an attorney representing himself. An attorney representing himself. So do you want to be pro per? Do you want to be pro se? How about real party and interest? That's a whole lot better. That's a whole lot better. It gives you a whole lot higher status than the fiction, because you're coming in as a real sentient being.
Gotcha. Okay. No, this
Yeah.
is helpful. Took just a minute to
Okay.
explain that, but it was important for people because they know if they're not going to use an attorney, they think they're supposed to use pro se, and that's,
Oops.
you know, the what does that do? But what does that do to your status?
That
It's still fictional though,
well,
right? Because
you're
you're not an
telling the
attorney.
court you're telling the court you're an attorney.
Right. And you're not. And
You're
you're,
not. It's a lie.
yeah, but they shouldn't allow it. Why would they allow it then? Because they know you're not
Because
an attorney.
because they're they see somebody come in saying all this stuff, and the first thing
Uh-huh.
the judge does is get out the shears, because they know they're fixing to shear another sheep.
Hmm.
Well, like I say, it's easy to fall into some of these traps.
I actually tried to file some papers with being a, with a status change, and they wouldn't allow them to be accepted. They wouldn't accept them. They wouldn't allow them to be filed because they knew I was changing my status.
We had that same problem. This one lady I was working with, she was wanting to put her papers in as pro se. Okay, if that's what you wanted to do. And then as soon as she put stuff in, the clerk would change it to pro per. And she sent a threatening letter to the clerk. Said, you go back. She said, I'll give you 3 days to go back and correct that. If you don't, I'm going to sue you. Because she didn't put it in pro per. All right, but a better position than either of those two things, a real party in interest. Real. Anyway, let's go through some more of this. And, like I say, I'll supply this and you can put it up for people to look at. They're asking all kinds of questions here that if they truthfully answer, they just hung themselves. Like, have any charge-offs been made by any creditor or debt collector regarding this account? Oh, yeah.
Well, if the original holder sells it, then that's a charge-off, isn't it?
Of course it is.
Yeah, there you go. So someone's already taken the charge-off for the loss. So.
Well, like when you go do a mortgage, close of escrow, the bank immediately sells the note.
Yeah, table funding. Yeah,
it's a charge-off.
This is such theft.
Well, I'm telling you,
this is theft, man. This is robbery.
And they're getting away with it because people lack knowledge. Like it says in scriptures, my people perish for lack of knowledge. So we're trying to give, a little bit of knowledge that might be helpful to people.
But why would he agree to this anyway?
Who?
Jesus. Why would he agree to this? Honestly.
Well, okay.
Why would he agree? This was such a bad idea. I'm sorry. I mean, these people don't know. And why is it okay that these souls keep reincarnating? I mean, what horrible, way to advance a soul.
Listen, Jesus is involved in equity, interest, recovery to the principal. Jesus is involved. The program is equity, interest, recovery to the principal, and the principal is God. Okay? Does that make sense?
Okay, right, because he came and
we're getting deep again now, darn it. I didn't want to do that again.
But Winston, we can't. I know, but sometimes we just cannot move forward without understanding, putting things into context of a greater understanding, and that's why I think this is what happens. And I always kind of didn't like when I was in college and I came across professors who wouldn't answer questions because I wasn't getting the full picture. And I think, sadly, you can't stick with a, you have a lesson plan for the day and this is what you're going to accomplish no matter what. But if people, aren't getting enough information to understand, some people need to understand it in a greater context in order to really understand how it all fits, all the pieces fit together. So I do appreciate you answering the questions, Winston, and I don't mean to get you off, your
well, okay, let me
your plan
express.
here for today, but it is helpful.
I appreciate what you do because you're speaking for the people who will be the listeners.
Yes, exactly.
Because they're going to come up with these same questions, or some of the same questions that you're raising right here, and so, but still. There's a few points that I really need to make, and some of those points might explain some of the questions that people are typically coming up with.
Okay, because if I only had a brain,
that's why I'm not willing to labor on one particular question for very long.
That's fine, as long as we can be clear.
Mm-hmm. because
Trying to be
what
fair.
happens is one question generates another question, it generates another question. Pretty soon we're not even talking about third-party debt collectors.
Well, no, it's just that when you come across a topic that, when something you're presenting gives rise to a little bit more explanation before you can move forward, we do have to try to make sure that it's clear, because then we can't understand what you're going to say next. I mean, it won't really put it into the context that we need. But we're doing good. So we got the answers,
Yeah.
and we're ready to move on. Thanks.
All right. Well, anyway, here's like 35 questions they're talking about here. And again, this is part of a court pleading. So it says upon failure or refusal of plaintiff to complete and return this statement and to provide verification of this debt, no photocopies accepted.
Yeah.
Plaintiff and attorney for plaintiff tacitly agree the plaintiff has no bona fide verifiable claim to this account, and respondent gives tacit agreement to waive all claims against Paul, the all capital letter, named herein, and to pay the real Paul for all costs and attorney fees involved in defending this account in this and any future collection action. Blah, blah, blah. Then, anyway, I'll send this, and, you can have it.
Okay, we'll
to put
have
with
the
it.
link. Okay.
Yeah. Now, you can also have some other fun, and we've done this other kind of fun stuff too. You can have ever so much fun, doing some of this stuff. I mean, it just give you a real chuckle, some of the things you come up with. So let's look at this other deal over here. Let me see if I got it.
So you're saying a court's not going to make you justify a prepay account?
Mm. Let's see.
These are rats running the show. I really hope there's
I think this is it.
Good
All
shit.
right.
Okay. Ooh.
Now, we used to love to do this. That was, when they come with an offer to contract, you go right back with another offer to contract with them.
Okay, what do you mean an offer to contract? Who's going to come with an offer to contract?
Well, let's say a third-party debt collector comes. Well, I mean, if they send you, some kind of correspondence, something like that, that's an offer to contract. Then you got right of refusal. 3 days truth in lending. T plus 72 and all that. But anyway, so obviously these people are interested in contracting. So hey, how about we offer them a contract?
Mm-hmm.
All right. So this is a real thing. I mean, this fellow I was working with in New Jersey.
Oh, Jersey, such a trouble state.
He was in Jersey, so I was helping him with stuff. And apparently, some debtors, whatever, gone to the National Arbitration Forum. That's an administrative private court. We talked about this a little bit in the past. But anyway, so in correspondence back to this National Arbitration Court, he said, "Well, thank you for your offer to contract. I'm under no obligation to contract with your company, but inasmuch as." But inasmuch as you seem intent upon contracting with me, I accept your offer to contract with me and stipulate to the following terms. Affidavit of contract. By your actual express agreement or by tacit procuration, you give Raymond his assigns or successors explicit power of attorney in regards to. See, again, we're setting this up, and if they don't respond, they got T plus 72 when they get this.
This isn't a filing, though.
Huh?
This isn't a court filing, is it?
No. It's private contracting.
Okay.
You could take it to court if you have to, but they offered the contract and say, "Well, I'm under no obligation to contract with you. But if you really want to contract, okay, here's the stipulations."
Exactly.
And that is explicit power of attorney in regards to. I knew a guy who used to do this crap all the time. I mean, he would get into a tacit contract with some corporation that they would allow him to use their letterhead. So he was going out and doing all kinds of fun things with their letterhead because they agreed to let him use it. Anyway, so I'm saying you can have a lot of fun with these people. But anyway, power of attorney in regards to this bank, apparently, that they had pressing this claim. The number two, by your actual express agreement or by tacit procreation, you give Ray his assigns and successors leave to appoint fiduciaries for and in behalf of National Arbitration Forum to liquidate any and all assets of National Arbitration Forum by involuntary Chapter 7 bankruptcy or any other fees available to Ray. It said by your actual express agreement or by tacit procreation, you agree you are indebted to Raymond for the sum certain of 100,000 or whatever much money in
Oh,
functional currency of the
it's
United
funny.
States and agree to pay to Ray the sum certain of 100,000 upon demand. Demand's now made. This is your first notice. And by your express or tacit agreement to be listed on the UCC1 financing statement as a debtor to Ray in the amount of $100,000. By your express or tacit agreement that this document shall serve as a security agreement and that Ray, his assigns or successors shall have perfected the security agreement between Ray and National. He's setting them up to do whatever he wants to with them. And so, if somebody, is dumb enough to go and, try to contract with Ray or me, I'll come right back at him. Recontract. Here's the stipulations. And if you don't respond, if you don't refuse to contract, T plus 72, regulation Z, technology. Now I got a contract with you, and here's the stipulation. Here's the terms of my contract, which I can enforce in a public court. So in this case here, we're getting them to agree to $100,000 and then to be put on the UCC financing statement as a debtor, and just having a whole lot of fun. That's what I'm saying. Turn it around on them. And so you got a third party debt collector or whatever. If you want to have some fun with them, just turn it around on them. If you want to press it far enough, there's money to be made. Put it that way. You understand what's happening here?
Yes. Yeah, but it's,
What?
It's getting, we're going to have to start.
You got to have a little fun with this stuff. Come on now. So, somebody wants a contract. You say, oh, no, I don't want to do it that way. But how about we do it this way over here? So we re-stipulate to the contract. And then, if they don't object to it, then they're in contract with you. Then you can execute on your private contract.
Right. Now that part is totally clear. And what probably might need a little bit more clarification is what does it mean when someone offers to contract with you by either sending you a bill or sending you a debt collection notice, or
in this case right here, what had happened, there was some outstanding debt. They had taken it to a national arbitration organization there in Minneapolis. And that's a real famous place. I mean, we've seen that a lot. I ain't heard so much about them for a long time. But so this arbitration company come up with a judgment in favor of this bank or whatever it was, and so they sent Ray a demand based on their judgment. And he said, I don't really want to contract that way, but how about we contract this way? Now, what do you think happened when he sent this offer to recontract back to this arbitration board? Do you think they're going to pursue it? Do you think that bank's going to pursue it?
No.
You see what I mean?
So an arbitration decision, if you sign it, it's an agreement to contract with them.
If you acquiesce to it, it will be.
Right, if you acquiesce.
Yeah, believe it or not, years ago, we set up our own arbitration court,
Did
and
you?
I was the judge.
Mm-hmm.
Oh, we had a lot of fun with that.
I bet.
Oh, well, if they can do it, you can too. Because again, it was I think it was in the 80s to relieve the burden on the courts, the civil courts. They came up with what was known as the National Arbitration Act,
Mm-hmm.
whereas an arbitration court, which is purely administrative, could determine facts and law. Uh-huh. And then the states picked it up, but as it turns out, all it is a private organization, a private corporation. So we went and set up our own.
Winston, honestly, the problem that I'm having with all of this is that you need to have honest judges in order for this to
I
work.
was an honest judge.
No. I'm saying that I believe you are. I'm just saying you need to have honest judges for this to work. That's the problem. And my experience is that I have not experienced an honest judge yet in my own personal experiences. One that maybe I would say has come close to it, but I can tell you that it is so corrupt. They are so in bed with, they don't care about you. They just want to make as much money off of your pain and suffering as possible. That I just have, a lack of faith really in the system itself. That other places you may have more success, but not in Jersey. I'm surprised this guy had any success at all in Jersey, that's for sure.
Well, the arbitration court was in Minneapolis.
Interesting. Yeah, I see. That may be why they got some success, because everything in New Jersey is about greasing the palms of their friends. Sorry, but
Yeah.
it's my experience, and I'm stating this from firsthand knowledge. That's my firsthand experience, that everything is as corrupt as it could possibly be, that there's no accountability at all either.
Well,
So people
yeah,
are really
that
screwed. People are
we're
really
trying to
screwed.
we're trying to
Very,
correct
very
all
sad.
that, and the only way to correct that is to correct the money.
Yeah,
You can't have honest courts when you have crooked money.
that's right.
The Federal Reserve notes are crooked money.
Did people even realize that the judges get a percentage of their dockets and that they
Well,
have
they do when we tell them. I mean, we reported on that
we
in
have
this
reported on it.
country road reports and so forth.
Hmm.
So
Exactly.
let's get along with some other things.
Hmm.
Uh,
But isn't there supposed to be some kind of fair notice or disclosure of that? Do you
like
think?
what? What do you mean? What are you talking about?
Well, should people have some sort of disclosure or fair notice that the judges receive a portion of their dockets? And so therefore, whatever the dockets total, are you talking about just docket fees or even judgments? Do they get
Okay.
portions of judgments?
Let me tell you the theory behind what's being done.
Mm,
And this is one of the main reasons why the whole court system, the whole justice system, ducked into an admiralty mindset.
mhm,
Mindset. And that is that under the admiralty mindset or the theory of how admiralty law would work, that it's about conflict. It's about, I'm trying to think of the right word. Maybe I'll come up with
Adversarial?
it. It's
Adversarial?
adversarial.
Yeah. Mhm,
Now, when something is adversarial, you're not required to tell the other party what you're doing. It's like you got two football teams out on the field.
mhm,
You got the one team that's on offense, and the other team is defending, and the offensive team does not tell the defense what play they're fixing to run.
mhm,
Defense has to guess. And so that's the admiralty theory, is that the government is running plays. They're doing different things. And they're under that admiralty process, they're not required to tell the people what they're doing. Now, would they be under a different law system? Would they be required to tell? Yeah, and that's what we're working for on disclosure. that you come forward and you tell the people what it is you're doing and how you're spending their money. But you can't do that under the Admiralty thought process. You can't demand that the quarterback tell you, well, we're going to do a run around end, or we're going to throw a pass down here in the flat.
And why is it adversarial? Why does it have to be adversarial?
Well, that's the nature of Admiralty, but that's why they are in the Admiralty mindset. That's their personal justification for how they act.
Mm-hmm. It's kind of Luciferian, isn't it? A little bit.
No, it's just a system.
A system.
Do you want
Okay.
that? Look at some of the other systems we had. You know, for instance, the French system. Under their system of law, you're guilty until proven innocent. If you're accused of something, the government automatically figures you're guilty.
Jeez.
You have to prove you're innocent. That's their system.
I know, but sadly, it really is how it works. People are automatically, just like this whole thing with Judge Kavanaugh. I mean, this woman 35 years later comes up and says she had, I mean, it's there's not even any credibility to what she's saying, but sadly, it still will put the question in people's minds, and you're automatically guilty, just in conscience.
Well, it didn't put a question in my mind. I knew exactly what them fool politicians were doing.
Yeah. Well, I just think
who was that? What was his name? Feinstein or whatever his name was.
Oh yeah.
Any voter in her district can be fool enough to vote for her after this. I mean, you got to have your head examined.
Yeah, in California.
Who would be fool enough to vote for that woman?
Yeah.
I mean, they need a whole succession of red pill suppositories.
Yeah, in California for sure. I mean, look at San Francisco district. It's horrible. Isn't that Maxine Waters, Mad Max's district? Oh my God. Yeah, go have more of that. That's your socialism, people. You vote for your communazis.
Yeah. Yeah, those are kind of bad things, but little by little, we're waking up as many as we can. And again, a lot of times people don't come to terms with the situation and until they open up the refrigerator and there's nothing in there. And they say, how'd that happen?
Right.
Why don't we have anything to eat? Why don't we have no electricity to our houses and all that kind of stuff? And then they go looking for who did it. So finally, these Waters and Feinstein and some of these others, they're going to get caught up with. But in many instances, people won't see it until they open up the refrigerator. There's nothing to eat. Now we'll come to terms with it. You see what I mean? That's unfortunate, but if that's what it takes, that's what it'll take, because that whole cotton picking state's going bankrupt.
Yeah, it's
short order.
Not in good shape.
I mean, you can get out there on Interstate 15, and you can see all the cars leaving California for other places. But back in the old days, people were coming to California. I mean, just people flocking to California. Now people are flocking away from California. Why are they doing that? Because their refrigerators are empty. They're saying we can't have no more of this. And they don't have the political power to stop it. And so they're simply leaving California in droves. Go sit out there on Interstate northbound 15 to just watch the cars and see what kind of plates they got on them.
They're coming up to Washington, huh?
They're coming anywhere.
Yeah.
So anyway, like I say, those things are slowly but surely, getting resolved and so forth. But anyway, back to the third-party debt collector stuff. I wanted to show another few things that, that might people. Let me see for a minute which one I want to look at. Yeah. Let's look at some of the technology, that we've used in the past that's been very successful in these situations. Let's see. Now this is a technique, that I had developed. We've talked about it before, but the first thing we do when we do some of these things is that we put somebody else in the position of having to resolve the matter. And one of these is known as appointment of fiduciary, or we call it fiduciary debt or whatever, because they have the liability. And then we talk about the different technologies and so forth, for this. We've talked about this extensively in the past, but this is one of the good techniques that's worked very well in the past. So I'm recommending it. And then, then we want to look at.
Yeah, I hope folks don't mind my questions. It's just I know there's some people who will have the same questions as I do, and
Oh, yeah.
I'm only asking for the benefit of the viewers, and in some cases for my own personal understanding as well. But I can only imagine that that others may have the same questions. So
I'm sure they do. All right, now again, once you have appointed the fiduciary, then the liability, on this case turns to the fiduciary to settle and close it. And so again, we've showed this in the past. So when we get a complaint of some sort, then we do an answer and counterclaim. Remember, we talked about doing everything in affidavit form.
mm-hmm.
All we do all our pleadings in affidavit form, because again, that's a catch-22.
Mm-hmm. Right, because it has to be rebutted by each actual point, and can only be rebutted by someone who has firsthand knowledge.
Exactly.
Again, it cannot be an attorney.
Yeah.
Exactly.
And so we go into negative averment on all of their accusations. And to overcome a negative averment, the other party would have to come in with proof positive of whatever allegation they had made.
So the burden of proof is on them.
Exactly.
Okay.
We don't have to prove it didn't happen, but they got to prove that it did.
Right.
So in other words, they have to deal with their own allegation. And so again, it is a custom of attorneys to make a bunch of allegations, which are assumptions. And then when you don't rebut the assumption, it turns into a presumption. And in a civil court, judgment can be given on a presumption. So the burden's on you. If somebody's assuming an allegation, then you have to act on it. So either you rebut the allegation, or you use specific negative averment, which makes them prove their allegation. I prefer to have them do it a whole lot easier. But they can't do it, first off, because of the lie anyway. But we're preventing an assumption from turning into a presumption, which judgment can be given on in a civil court on a presumption. All right, so again, we go back through all this business. Then we come in with a counterclaim. This is our favorite part, because when we come in with the counterclaim, then we're going to come in with a well, this one here I don't have it exactly, but we come in with a true bill and so forth to do that. Now, these are some of the things we've gone over in the past. For those that are interested and still haven't gotten a copy of the DVD on civil court, I would suggest you get that DVD for a full explanation of just how that process works. Now, the other process, in dealing with third-party debt collectors, which have been very, very successful, again, is a prove-up, and that is, let's say, okay, I'll give you some quick statistics. If you do acceptance for value, for instance, on a credit card, the statistics are that 80% of those will be well. First off, they're going to sell every last one of them. They are to third-party debt collectors. In 80% of those cases, it'll be a letter writing campaign. 20% of those cases will actually go to a summons and complaint. And so you can handle it this way that I just showed you there if you want to do a counterclaim. But if you just want to kill it, make it go away, then the easiest way is through the process of subpoena duces tecum. Now, a subpoena is what's known as an extraordinary writ. It's technically, in the world of common law and or equity. And so when you have an extraordinary writ, you're kind of working in that realm. Now, a subpoena duces tecum is a particular kind of subpoena because you are requesting documents. Okay? So documents. Now, each court has their own style. I was just looking at one the other day. A lady sent me from New York, and I like the way they had put it. I mean, I like that subpoena. But if you want to do subpoena duces tecum, let's say a case is started, and on a third party debt collector situation, you would go to the clerk of the court, and every court may have different regulations and so forth. But like I say, the first time I decided I wanted to do a subpoena duces tecum, I just went down to the clerk of court and said, hey, I need a subpoena duces tecum. She just said, how many do you need? I said, oh, 6. She just went and gave me 6 of them right across the counter. So every court's going to be a little bit different, is what I'm saying. Now, so you go to the clerk of court, say, I want a subpoena duces tecum. And so what you're trying to subpoena is any and all original signature documents that creates a liability of the defendant to the plaintiff. Any and all original signatures. Again, that's a catch-22 because you know they ain't got it. All right. So then you give it back to the clerk. The clerk said, okay, it's going to be 40 or 50 bucks, for the sheriff or the constable or whoever to serve the subpoena. Now, at that point, then you're going to put in a court pleading requesting a hearing on the subpoena. Okay, so you have to have a hearing on the subpoena, and you have to initiate that. So, the clerk will set up a hearing, for this subpoena. Now, here's the key to it. And people, please, make it as simple as possible. Because when you get to the subpoena hearing, there's only one question that you're going to ask the judge. Now, it's your hearing. And I don't care who else shows up from the other side. If they start talking, just tell the judge, hey, this is my hearing. I get to talk first. Tell the guy to shut up. Really? Tell the judge, hey, that guy, tell him to shut up. This is my hearing. All right. So you have one question and one question only for that judge. The question is, Your Honor, has there been a return on the writ? Now, that's a yes or no question. The judge has to answer your question. Your Honor, has there been a return on the writ? Now, the judge would typically turn to the other party and said, did you bring in the subpoenaed document? Well, blah, blah this and blah, blah that. And blah, we got copies. And we got this. And we got that. The judge would turn back to you and say, blah, blah this and blah, blah that. They got copies and they got this, that, and that. Your Honor, back to the original question. See, they're trying to get you going off on a different direction. Your Honor, back to the original question. Has there been a return on the writ? See, you have to make the judge answer. And he will answer if you keep putting the pressure on him. Because what did the subpoena say?
Any and all.
Any and all original signatures.
Right, original signature.
Documents that creates a liability of the defendant to the plaintiff. Finally, the judge is going to do what?
Dismiss.
He's going to say no.
Oh, yeah. Okay.
Now, at that point, what I would do would just say, well, the court on its own order ought to dismiss this case. And they probably will. Or you might have to put in a request for a dismissal or something like that. But when you do the subpoena, and you have the hearing, to just, put a card or something out in front of you with that one question on it. Your
Mm-hmm.
Honor, has there been a return on the writ?
Mm-hmm.
And don't let them draw you away into anything else. Your Honor, back to the original question. Your Honor, back to the original question. Your Honor, back to the original question. And finally, he's going to have to say, no, there has not been a return on the writ. Okay, well, thanks very much for that, Your Honor. The court on its own order ought to dismiss this case. Why would they dismiss it? The failure to prosecute, this is a 12B6. There's no relief that can be granted to a claim that doesn't exist, for crying out loud. Now, this is a shortcut to what this other deal was with the counterclaim and so forth. It's a shortcut, but it'll get it killed. It'll knock it right in the head. You see.
Okay.
So like I say, it's been used very successful by a lot of people. This one, like I say, this one guy showed that too back in New York. He actually went into business. He would take clients on, and he would use this process to kill third-party debt collectors.
And this goes back to, to back this up legally, you're going back to the UCC Section 3.
No, this had nothing to do with that.
Okay, because they're going to ask you
this is all procedure. No, they're not going to ask, because you're not going to have but one question. Okay, this is procedural.
Okay, there we go.
Got nothing to do with proof or statutes or nothing else. It has to do with that extraordinary writ that subpoena dues is taken. It's all procedural. And so what you're doing is it's a show cause to see if there's anything to be talking about over here. That's exactly what it is. It's all pure procedure.
I'm saying that it would be based on, and he would make that decision based on that there are no original signatures. And I'm trying to say that the original
No. The decision is based on they didn't return the writ.
Right. But they didn't return the writ because they don't have the original signature, and that the original signature is why because they have failed to produce that. Now I'm saying that the UCC3, you're saying Section 3 is where the law is based, that they have to have original signature to be the holder of due course.
Well, yeah, that's in the background, but using this technique is pure procedure. You're not talking about UCC or anything else.
No, but you need to know that that's the basis for it.
You don't have to.
I think people should know that. I think they should know.
Be fine. But all I'm saying to you is that this is a quick fix for a third-party debt collector suit.
Yeah.
On the one more complicated, where you appoint fiduciary, you come back into the counterclaim and all those kind of things. That's much more detailed.
Right.
And if you don't want to go to all that trouble, just cut it off right there on the spot with a subpoena.
The problem is when there's an electronic signature, then it can be reproduced. If you sign something, and all these school loans, the FASA applications are all signed electronically. So you're contracting with them. It's an electronic signature, so it's not really original. But you sign it as it tells you by typing your name in here. You're signing this as an original, or you're signing this as your signature. You're giving us your signature, so to speak.
Well, then on your subpoena dues is taken, then you would subpoena any witness with firsthand knowledge that actually saw you do that.
I see. Okay.
But what you're talking about is that FISA and all that kind of stuff. That's not a third-party debt collector anyway.
FASA.
I'm just talking about third-party debt collectors to help people deal with some of these, minor problems that we're not talking about the full-blown FISA problem we're talking about here. We're talking about
FASA.
People run into these little yeah, these people are running into little skirmishes with third-party debt collectors. That's all I'm really talking about.
Well, who's servicing the loans for the Department of Education or FASA, federal government, who's providing
what do you mean servicing?
Well, who's servicing the loans? Who owns the debt? I mean, who owns the loans? Has the federal government, what have they done with your signature? They have gone to the federal.
They monetized it. They either took it to Treasury or they took it to a bank on special deposit, one of the two. But either the Treasury or the bank created the money to pay for your tuition and books and all the rest of that. And they got it out of
the Treasury. they've
Yeah, they
already
got it
been
out of
paid
your
on.
they got it out of your account that was created by the birth certificate,
Yeah.
which again is a probate problem if you want to pursue it over into probate. So, like I say,
Indeed.
today we're just trying to give people a little bit of information about, a little bit about negotiable instruments, hold and do cores, and all these kind of things, and then bring to the table a few ways that you can handle this in court, or if you want to recontract with them and fool with them like Ray from New Jersey did, you can do that, or whatever. I mean, you can have fun with it if you ain't got time to screw with it, and just kill it with a subpoena.
Den of Thieves.
Well, that's true.
That's the name of our report today. Third-party debt collectors, Den of Thieves.
Yeah, yeah. Well, we're coming up on 2 hours, so I wanted to
Yeah, we're
push
good.
I
So
wanted to push a little bit, make sure I got those points, in,
yes,
so that people would have that information available to them.
thank you, Winston, for doing that.
Again, I
Very
would
important.
recommend highly uh, the uh, civil civil court DVD.
Mm,
Listen, we've had ever so much fun with that technology, man. You can't believe. I mean, we literally using that technology in there. We put one of the major
mhm.
foreclosure attorney fees out of business in Las Vegas, running right back to California where they come from. By doing using this technology that's on this DVD. And so, again, you know, uh, we do have solutions. That's what solutions to commerce is about, is producing solutions to problems that people encounter when the original plan is being perverted, because the prepay is there. I mean, we've shown several proofs of it, so forth. And then when you find people, banks or attorneys or courts or whoever, politicians or whoever, that avoid that, that's thievery. They're thieving from the beneficiaries. That's what they're doing. And
Hmm.
so we're just trying to give some technology to correct the thievery. That's what we're doing. And I think people will be, greatly pleased with this information. And so, like I say, it's not that difficult. I mean, to understand some of the underlying concepts might be a bit difficult at first,
Mm.
but you don't have to be a genius on the Uniform Commercial Code to go do a subpoena, man. All you got to do is go to the clerk, have it served, call a hearing, and bingo, you're in the ball game.
On these concepts, one of the things I'd like to do, short of Nasara, is I would love to do just like little courtroom simulations of these things so that people can
Okay.
actually see in real life what it looks like when you go in there and how to deal with situations that happen when you're in a courtroom, because it's very intimidating. And they do it that way, as you've said in the past, on purpose. So, but thank you, Winston, very much for bringing this information to us again. As always, we really appreciate it. Appreciate your time and your wisdom. You've put a lot of
Well,
time.
let me just say, in regards to, we have talked about a little bit of quantum physics in the past, and structures do create certain energy. If you just walk inside of any courtroom,
Yes.
and look at the architecture of that room, and realizing, what's it called, feng shui,
Yeah.
you
Feng shui.
arrange things in a certain way to create a certain energy.
Yes.
And so those courtrooms are set up to create that negative energy.
Mm-hmm.
Now, if you get into a situation like that, and you feel like that you're being unduly
Mm-hmm.
influenced by that energy, just call in the angels. Ask them to come in and correct the energy. To me, I'm not threatened by the energy. I think it's pretty good fun, because I just turn their energy right
Yeah.
back on top of them.
Mm.
But other people, who don't, who might get into those situations, where they are under energetic attack,
Yeah. Definitely.
to just say, I'm calling in the archangels to correct the energy in this room, or I'm calling in the angel of peace, or whomever, to correct the energies here, because it's exerting undue influence on me at this time in this moment.
And I gotta tell you, that's how I felt when I walked into the Catholic Church. I felt
And
energetically, man, I was being attacked. It did not feel good. I didn't understand it. I just thought it
Well,
was,
there's
now
a
I
reason.
know, but I mean, I didn't know then, yeah, but I can
Yeah, there's
recall.
a reason they build those buildings with the architecture that they do.
Yes.
Like I say, as I walk along, I mean, there are some buildings that I physically simply won't go into. I know
Yeah.
what kind of energy is inside there,
Yeah. Yeah. And
and I just don't want to have to fight with it.
I didn't understand that. That's ultimately I understood that, why it was that way, why I would notice and sense the energy as being like an opposite or counter energy to my own.
Yeah.
So it was, yeah. But
Well,
anyway, so
that's why I had shown that Joey Corn book,
right.
because Joey's technique through the technique of prayer is to take any negative energy and turn it into positive energy for balance. And again, what Joey showed there was a really, really good technique when you get into a situation where you're being unduly influenced by negative energies. He just converts them into positive energy through prayer
Mhm.
to whatever God you want to talk to. It's actually the God within that does it, to be perfectly honest. But in any event, he
Mhm.
converts the energy to positive energy to remove any
Mhm.
negative influence. And then you got, James Gilliland has a technique to remove any negative influence. A lot of people develop that kind of technology, so it can be done. So if you get into a situation where you think you're being unduly influenced, I just like to take their energy gathered up and turn it back to them. Let them eat their own
Mhm.
stuff.
Hmm. All right. Well, thank you, Winston, very much. Again, it's been another a little delay, but we seemed to manage to get this report done today. But there was something I had to do to allow that to happen until this gets serviced and fixed, because there was an attack on the internet, and so we have, but we made it today. So thank you
Yeah,
very
yeah, yeah.
much.
Like I
We got
say,
through this.
we do things with a good spirit and a good heart. If I didn't think I was helping other people by doing this, you can rest assured I wouldn't be doing it.
Oh boy, I need some more sleep.
Gazoon type,
No,
gazoon
I
type.
was yawning.
Oh,
Uh,
yawning! I thought you were sneezing there.
no, no, they were at my house at 7 o'clock this morning trying to fix the cable. So,
Yeah.
and then
Well,
the
like
late
I
night.
say, we started out with a little bit of humor for a good laugh and everything, and so we've tried to keep our spirits up,
Right.
uh, to get our message across. And like I say, I do appreciate the questions you ask, because I know somebody out there thinking the same thing you're thinking. Maybe someday we'll simply do a country road report, and you just ask me. Maybe
Yeah.
next time we'll just do that.
Just ask clarification questions about certain things. What we can
Yeah.
do is ask the viewers to put, now look, I need to view the viewers to kind of help out here, because if you're not getting these reports in YouTube, or if you're not able to comment in YouTube, please let me know. If you're having trouble accessing it on BitChute, we're being shadow banned, and it is very, obvious when we look at the number of views on the reports. Please subscribe to our channel if you haven't, so we can, see Winston do Hambone. He has promised once we get back up to our
There you
original
go.
subscriber number that he'll do Hambone. Come on, don't you want to see Hambone? Come on, firsthand. It'd be wonderful. But we need to get your response on whether you're receiving this, and if you look at the publishing date, if you're receiving it on the date that it was published as well. So if you can give us some feedback on that, we would be really grateful, because it's really hard for us to gauge how quickly you receive it, or whether you're receiving it, and you know because it is being shadow banned. But also, please follow us on Twitter. Like us on Facebook, follow our 24/7 news page, where all the information and latest news that you're interested in, that relates to and ties in stories we talk about on GoldFish Reports, POTUS Reports, and things like that. And all that news is there for you on the 24/7 news page. But please support us. This is a viewer supported program, and without your support, we can't bring this to you. If you're receiving quality, and you're benefiting from this, it would be doing your part to help support this and to keep it going, because it's a tremendous amount of expense and time on my part to keep keep it going. And if I have to spend that much time to do this, I can't spend my time elsewhere. And there are many costs, not just to maintaining this and keeping this, but you know, in my own world as well, since this is what I dedicate all of my time to doing at this point, to bring this to the viewers. So we also appreciate your feedback. So for the next report, Winston, what we're asking viewers to do is to put questions, clarifications on things that we've talked about in the past that you might not be clear on. You know, the viewer might have a question or might need some more clarification.
Yeah, we'll dedicate the whole program just to that.
Question and answers, but not a specific question about a personal matter, just understanding how something works.
Yeah,
because we can't answer questions about personal matters that you have. You can email Winston for that, or schedule a consultation with them for that, because it takes a tremendous amount of time. But if you have a general question to clarify what he's been teaching, then by all means, please put that in the comment section of the video, so we can go through that comment section and answer your question directly. We will do that live in our next program for you. That's a great idea, Winston. I think that's a wonderful idea. And I'm going to announce that also in my reports. I have a few more reports coming out over the next few days. So I'll also mention that, so we can have that clarification for folks. If
if it gets to a point, you got quite a few of them, if maybe you could type them up or put them in an email and send it to me, so I could look at those before I get, because I might be able to supply information or documents or anything, you know.
Well, it's all going to be public. This way people can see what other people have already asked. This way we don't have 50 people asking the same kind of question. It's all going to be, and I'm just asking not to email it to me, but to please put it right there in the comment section. So Winston can see the comments, the questions yourself. You can see them right there. You know, you can take a look at and I'm not saying I wouldn't send you the email, but they should be right in the, what I'm hoping and I'm asking viewers to do is actually put your question right in the comment section of the video, this video. So if you have any questions about anything we talked about on previous country roads, please put your questions in that comment section so Winston can see them and we can address them in our next report. And we will, and you will, right, Winston?
I'll do my best.
Okay, that's great. Well, have a great weekend. It is Saturday. It's time to get rolling, and I hope you have a nice weekend, Winston. Is it a good weather over there?
Yeah, the sun peeks out every once in a while, but every time the clouds go away, I see the idiots are up there spraying more chemtrails. Just absolutely sends me into a rage.
And we are just being sprayed like cockroaches.
Yeah.
But, you know, we need to stop this. We all need to get up and stop it. I don't know how else it's going to stop, because there's you know, we're all getting sick from it. So, all right, folks, that's it for this weekend. We'll be back next week with another edition of Country Roads. Of course, we'll have that Q&A, and we'll also be back. I have a very special interview coming up called Steel Magnolias with some very special women, and we will be airing that next week as well. And of course, Monday for our POTUS report. So thanks for viewing. Please subscribe, and know that you have to go to the goldfishreport.com to access the POTUS reports on YouTube, but not on BitChute. BitChute, they're all up there. But I know some people have had some trouble with the interacting with BitChute. I don't know if you have to resolve that somehow, but YouTube, they're unlisted. That's why you're not going to see them on the YouTube page. They have to be uploaded as unlisted. It's the only way to keep Jim Fetzer on YouTube right now. And so you can access those unlisted links from thegoldfishreport.com. Our blogs have not been restored, as our viewers might find out. We do have a new blog at Canary Chronicles. They're publishing our Goldfish reports right now. And that link will also be in the description section, but it's also on the front page of thegoldfishreport.com. So all of our links to all of our reports, you can always, to the channels that we have.
Let me start a new conspiracy theory. You know, for those of you who have seen, you know, different YouTube taken down and blogs taken down, go back and look at who they restored and who they didn't restore. New conspiracy theory for you.
There you go, Winston. Thanks. Our big conspiracy theorist now. All right, we'll talk about that next time. Thanks. So, folks, have a great weekend. Thanks for viewing, and this concludes this edition of the Goldfish Report.